okay. It's no big deal. I just
Yeah,
paid.
yeah, there wasn't any testimony taken,
When I
so
looked up and I
we'll
saw
we'll
nothing.
put that on the record. In fact, I could do that now. Which one was that?
That was Johnson and Lester was here, but Johnson was not.
All right, in the matter of Johnson versus Lester, I neglected to make sure that the record was running. It was live streamed. I granted Mr. Lester's motion to terminate the PPO and dismissed the order to show cause because of Mr. Johnson's failure to appear. Okay, let's see. We have Holmes versus Trudell. Let me bring them in. Okay, sorry it's been such a long wait this morning, folks. This is a matter of Holmes versus Trudell. Mr. Trudell and Ms. Holmes are both present. Give me just a moment to refresh my memory as to what this is about.
It's about our current custody agreement.
Hold on, Mr. Trudell. I've got a written summary from the referee. I just wanted to read that. Okay, so it looks like, Mr. Trudell, you are seeking equal parenting time on a essentially week-on, week-off basis, and
Yes.
Alternating ability to claim the child for tax purposes.
And that part right there isn't set in stone. Like if we can't agree on it, I could care less about the taxes. I just want to have my son 50-50 parenting time, and I don't want to pay child support. Just because for the last 6 months I've had him for 50-50 and on her time, and I wasn't paying child support. So this is out of nowhere.
All right, well, hold on. So, Ms. Holmes, you did not appear when this was in front of the referee. Let me ask you, are you opposed to a 50-50 parenting time schedule?
Yes, recently things have come to light. Actually, the March 18th of 2021 is the day that I officially decided that I was no longer comfortable with 50-50 custody.
Why are you uncomfortable with 50-50?
Well, the day that on March 18th, I went to pick up Atticus. Cody, per usual, was not home. He was with Brooke. Atticus was with Brooke. And when I picked him up, Brooke told me that he had woken up in the middle of the night screaming and crying, burning fever. When I asked if she took his temperature to see if it was serious and needed to go to the hospital, she said no, because they were too tired. I don't feel they have a newborn in the house, and I don't feel that they have the time or the energy to take care of them the way that they need to be taken care of. I'm very concerned for his health while he's there. They have people in and out of their home constantly during a global pandemic. I picked him up a couple of weeks ago. They had at least 20 to 30 people in their home, and that makes me very, very comfortable.
That's
all right.
Untrue.
Well, hold on. I'm not going to take testimony today. It looks like I may have to schedule a time when that can happen. How old is Atticus?
He will be
2.
3 in August.
3 in August. Okay. All right. So in order for me to change a custody order, unless the parties are in agreement, there has to be testimony taken and a determination made that the requested custody arrangement is in the best interest of the child. Today is just a motion hearing where I find out if there's any kind of a reasonable basis for me even to go down this road. And given that there was actually the practice of shared parenting time for some period of time up until when it just stopped, that's a sufficient basis for me to order that parenting time be revisited. So what I'm going to do is schedule a matter for an evidentiary hearing. I would hope between now and then, whatever the concerns are, you can work them out and resolve them. I think it's in Atticus's best interest if the two of you are getting along. On the other hand, it sounds like there's reasons why maybe that's not taking place, but try to resolve those things.
Yeah, there are other that
Can
I
I
like.
make one statement?
You can, but I'm not going to remember it. Go ahead.
That's okay. I just want this to be known. None of these concerns were ever brought to light until, and she still hasn't said this to me, but nothing was a problem until I asked for every other year taxes, and she literally told me that this was my fault because I got greedy. I could care less about the taxes. I just want everything to go back to the way it was.
Well, just remember to tell the referee that at the evidentiary hearing. I'm sure you'll be interested in hearing, but I'm going to refer this to the friend of the court to conduct an evidentiary hearing on parenting time.
Now, if I have paperwork that I need to, because I actually have a statement from management of my work saying that I approached them on March 18th, telling them that I was no longer comfortable with 50% custody and I needed my hours cut. Cody didn't even ask to claim him on his taxes until March 25th. So if I need to turn in this evidence, do I need to do that, or how do I do that?
If you have documentary evidence, you would want to have it available at the hearing. If it's something that comes from a witness, you would want to have that witness available to testify at a hearing. They can testify by Zoom, just like we're doing it here. If you need a subpoena issued to make sure somebody's attendance is compelled, and this applies to both of you, just submit a subpoena to the clerk's office. They'll send it up to me for signature. That will ensure that any witnesses, either who are not willing to come voluntarily or who perhaps need to show their employer something in order to get time off from work, that vehicle is available to you.
Can I ask a question? Are recordings admissible or allowed?
It depends on what's being recorded, but if it's a recording of something that Ms. Holmes is saying, absolutely, you can submit that. Similarly, if she has a recording of you, she could submit that. If it's a recording of somebody else,
printed out
text messages, absolutely, those are fully admissible.
What if it's a recording of my son, because I record him every time I tell him he's going to his dad's and he screams and cries and says he doesn't want to go? Is that?
That's literally
if you have that, I would probably admit that.
Okay.
That doesn't mean anything. 6 months straight, he was with me every day except for Tuesdays and Sundays. I have a literal text messages of that.
And things like that.
All right. Hold on, folks. Hold on. Save this for the referee. He's the one that's going to be hearing this. You'll be getting a notice of that evidentiary hearing. Have all your evidence present then. Thank you.
Okay.
Here's an order for that last one.
Yeah, I don't even know where it is now. Keller. There we go.
Judge, on the Martinez Schmucker case, George Lyons emailed and said they.
Yeah, Shannon already told me.
Okay.
Curl versus Orr. At last, yeah. Mr. Trudell was signed in twice. So I've got Curl and Orr. Who's this Ramey?
Mr. Orr might be on telephone.
Oh, Ramey's not on until 1:30. Let me bring him in. Mr. Ramey, can you hear me? Mr. Ramey? All right, well, Mr. Ramey, your case isn't scheduled until 1:30. I don't know if you can hear me, but I'm just going to remove you at this time. And that brings us down to the last one. Good morning, folks. Sorry to keep you waiting so long. Unfortunately, you are at the bottom of the list. Thank you for your patience.
That's all right.
So this is a matter of Curl versus Orr. Both parties are present. Give me just a moment to read the summary from the referee. Okay, I do remember this. This is one where I granted the mother's request to move to Texas and reserved Dad's parenting time because he was in jail.
Yep.
And provided that he has the right, once he gets out of jail, to petition for a specific parenting time. I know, Mr. Orr, you were not in support of the change of domicile. The reality is, because Ms. Curl has sole legal custody, I could not deny the request, even though
Right.
she had to ask for permission. That's so I can address the issue of parenting time. Since there wasn't any parenting time taking place then, there wasn't a whole lot I could do except grant her request, reserve the parenting time until such time as you were available to come out and request it.
Right.
I did make an effort to include you in that hearing, although the outcome probably would have been just the same anyway. But Eaton County Sheriff's Department was very uncooperative in making you
that's
available for the hearing.
Yeah, they told me that for some reason that Jackson County never got a hold of them, and I don't believe it. I just think I think they didn't want to do it, honestly.
Oh, in fact, I did get a hold of them. They had told us that you would only be available at 3:00, and then they told us there was no time, that it was impossible to produce you on that particular day. So, and they say that they only make people available at 3:00.
Yeah, I don't understand why it was like that, because I had went to a friend of the court meeting in August with my first child's mother, and it was early in the morning. So
if I had known sufficiently in advance, I could have issued what's called a writ of habeas corpus and required them to make you available. There just wasn't time to do that. But the reality is I was in no position to deny her request, and you were in no position to exercise parenting time anyway.
Right.
So here we are. You do have a right to a hearing regarding parenting time. I know, Mom, you're concerned about parenting time given his criminal activity, but I can't decide. I can't just say, well, because he got convicted of CSC with a 15-year-old, that means he's unsafe with his 1-year-old child. The reality, though, is whatever parenting time, assuming I order some, is going to be challenging given the distance.
Right.
Ma'am, have you relocated already?
Yes, sir.
And Mr. Orr, I'm assuming your intent is to continue residing in Michigan?
Yeah.
So one of the things with a child this young, it's challenging, but as the child gets older, I don't know how frequently, Ms. Curl, you plan to return to Michigan, if at all. Do you have family here still?
Yes, sir.
So you'll at least become your parents?
My parents and my husband's family as well.
All right. So you've got all the grandparents are located in Michigan, correct?
Correct.
And they're going to want to see their grandchild.
Yes.
Let's talk about Mr. Orr's parents. First of all, Mr. Orr, do your parents live in Michigan?
Yeah, all my family lives in Michigan.
Has Atticus, I'm sorry, that was the last case. Gabriella, I see that. Gabrielle, does she see Mr. Orr's parents? I mean, are they involved in her life at all?
Nope.
I haven't been.
His paternal, so his mother has decided not to be a part of her life, which has been perfectly fine with me. I've told her if she wants to reach out, I'm more than happy to bring her over, spend a couple hours there. His mother said that she didn't want me there. She would only want her by herself, and I just haven't felt comfortable with that. Since then, I do know.
I'm sorry, Ms. Girl. I don't mean to cut you short, but I was just looking for a pretty simple answer. Sometimes that's a good solution when there are concerns about safety, et cetera. If there's a family member that you do feel comfortable with that is involved with the child, I'm just exploring. I can't resolve this morning. This can only be resolved by taking testimony. So let me ask. So what I'll do is schedule it for an evidentiary hearing that will be conducted by the friend of the court. Go ahead, Ms. Curl.
Right now, we do have a PPO in place. And also, it is now part of a condition of his probation that we have no contact.
I already put in the motion to deny. I already had a motion to terminate that.
All right, hold on. PPO does not prohibit parenting time, okay? Sometimes that can create obstacles in exercising parenting time, but there is no PPO that prohibits parenting time unless it's a PPO issued on behalf of the child against an abusive parent, in which case the PPO is the least of the concerns. I wouldn't allow parenting time with an abusive parent, so PPO is not an issue for me today. So, Mr. Orr, let me ask you, is there currently a term of your probation that prohibits contact with a minor?
No.
All right. So here's what I'm going to do. I'm going to set this matter, send it to the front of the court to do an evidentiary hearing, and you would both have to present testimony, and the referee will be called upon to make a decision regarding parenting time, the scope of parenting time, how in the world that's going to work with the distance. And you'll each have an opportunity to present testimony at that. So let me ask, when was the last time, Mr. Orr, that you were involved in Gabriella's life directly?
April of last year.
I'm going to guess she probably wouldn't even recognize you if she saw you today.
Probably not.
Okay. I really can't resolve anything today other than to say, as I indicated in the order granting the change of domicile, that Mr. Orr has the absolute right to request a parenting time hearing. So I'm going to grant that. There will be testimony taken and a decision based on what's in Gabriella's best interest. So you'll be receiving a notice of that. Again, sorry to keep you waiting for so long. Have a good day.
It's all right.